Hi, thank you so much for joining me on The Same Drugs. I'm really looking forward to talking to you.
You too, Megan. Thanks for having me.
So let's get right into this.
There's so many different things to talk about, so many different
You're
angles.
you're a lawyer. Why don't you tell me a bit about yourself first? I mean, what kind of law do you practice? What are you,
Sure. Yeah, so I think like you, I went to SFU, did my undergrad in political science and women's studies, gender studies, and did a master's in political science at SFU as well, and then went to law school at U of O and then UBC, try to make my way back home. And then basically, I knew I was going to be a litigator. I love the courtroom. And so I got into a big downtown law firm. And then I'm not super experienced. So I'm like at maybe like a 5-6 year call now. But I clerked with the Supreme Court in Westminster, which is clerking is you basically work with judges for a year, helping them write their decisions, doing research, which was probably the best job I've ever had. I loved it. You can just, I don't know, spend as much time as you want on legal research and not have to worry about billing and clients. So that was really fun. And then as of this year, moved from Vancouver to the Okanagan and started practicing at a smaller estates boutique firm. And it's been really fun as well. So,
awesome.
yeah.
And so, you've been involved in a bit of controversy in the last year. And so as I understand it, back in December of last year, the BC Provincial Court and BC Supreme Court announced that lawyers had to use preferred pronouns in court. Is that correct? Am I getting this right?
Almost. So there was a practice direction, as is called in Supreme Court, notice to the profession in Provincial Court, that normally when you start a hearing, you come before the court and you say, okay, my name is Shahdin Farsai, or you just say S. Farsai. I'm counsel for plaintiff, defendant, whoever. And you obviously state the name of your client, and you sit down and you get on with the show. But there seems to have been some consultation that the courts, provincial and supreme, that the courts did with a CBA group. The CBA is the Canadian Bar Association, and we have different chapters. So there's the BC chapter, and this one is called the Sexual Orientation, SOGIC, Identity.
Oh, I have it here. Sexual Orientation and Gender Identity Committee, right?
There you go. Yeah, that's them. So they consulted. The details of how that consultation came about is not entirely clear to me, but essentially from the press releases that there was some consultation that occurred with this group, and then the courts thought it wise to issue this direction that essentially says, when you come to court, you will provide, you should. That's exactly what is said, that the word should is in there. Mm-hmm. Your manner of address, miss, mix, MX, whatever else it might be, and the correct pronoun. Okay, so the correct pronoun, okay, I think what they meant is the preferred pronouns, and then that's fine, because lawyers were doing that already. A lot of them were, and they did not need the permission of the court through a practice direction to pronounce their pronoun in court. But the second bit is what, in my naivete, I was like, oh, well, that looks a little bit strange, that the court clerk, who's the one that normally asks you these questions, said, and if you don't, you will be prompted to. So the court clerk will ask you, what's your pronoun? And I was like, well, okay, having just understood over the past year something that you might even laugh at me, but I didn't even know who Jordan Peterson was up to about a year ago. And I'm not kidding you. Like the first 5 years of being a lawyer, you're just so steeped in trying to learn your craft, it's just so overwhelming that wasn't even following current events. Like, so in 2016, when all of that broke out with Jordan Peterson, I was probably like, I think I heard something in a newspaper, but I didn't know what it was about, and I couldn't care less, and I just went about my articles. But over this past year, I kind of was able to take a little bit of a deeper look at some social trends, which I mean, of course, the pandemic has given us a pause on many fronts. And I just, something didn't sit right with me about this direction. And in my foolishness or my courage, I decided to write something about it, and that's what got me into trouble. So,
I mean, so, like, as I understand it, the BC bar wasn't asked for input on this. I mean, how did this even get pushed through? It's just this, it seems like it was just this one committee, this sexual orientation and gender identity committee, that really wanted to push for this directive, and it worked quite easily. Like, what's the process for this normally? Like,
so normally you have to be invited by the courts to have any input on anything. You can't just like lobby them directly. That's, I would think, quite inappropriate to do that. So my understanding is that the CBA SOGIC group, the BC chapter, when you look at their profile on the CBA website, and you look at the things that they have been pushing for, they have a pretty activist agenda. It's not this like benign, like let's have another course on X legal subject matter to help lawyers understand this new area of the law, or the regular boring stuff that we do with our continuing education courses. And it just, I mean, they have clearly, even before this broke out, they have already made it a point to, they're seeking eradication of the forms of address of my lord and my lady in Supreme and Court of Appeal. They are pushing for gender neutral bathrooms in all courts in BC. That's what they've said in their press releases. And so I don't know the mechanics of how that went about. But I also read something in one of the press releases where there are also judges that are members of SOGIC, and that one was a bit strange to me. I was like, I don't think judges are part of CBA subcommittees. I don't know if that was a typo, but if that's the case, then there's literally a judge that's part of this committee that probably invited them or was sympathetic to what they were trying to achieve. The other thing I noticed was they had previously written to the Law Society president seeking an opportunity to train new lawyers in so once you're done law school and you pass your exams, you still have to do the BC bar, which is it's a course that you have to take, and then there's an exam at the end. And they were wanting to have a mandatory session where they teach new lawyers about trans identities, gender fluidity, and all of that. And I read that letter, and it was quite overwhelming in that it threw in there like indigenous identities, and I was like, wow, this group is really purporting to speak on behalf, or is educated on behalf of a pretty diverse group of society, and I'm not sure if they are the be all and end all that the courts would want to just consult with one group. I mean, this, I'll cut to the chase. This is clearly, in my opinion, not a benign issue, and I know you can dress it up as a lovely inclusivity project, but it's obviously much more involved than that. And in my opinion, the courts made a big error by stepping into a very charged area of a debate that's going on in society currently. And unless you've been living under a rock, you will have noticed that issues of subjective gender identity and anything, God forbid, rooted in biology is going to be debated. And as you're aware yourself, that you can get canceled, and not published, and whole careers are ruined. And it's been really quite sad that I saw so many people cancel this year on various issues, including this. And then I was kind of canceled myself, and I was like, wow, okay, so that's what it feels like. But I mean, I'm happy that I spoke out, and I would do it again in a heartbeat.
Right. So let's talk about what you wrote in your article. What was it actually that you argued? I know that, the attacks on you, the response to you from these activist lawyers, this kind of thing always goes the same way. I mean, you're accused of being bigoted, you're accused of, being hateful, you're accused of erasing trans identity, or invisibilizing people, or denying that people actually exist. And of course, that's, I think, never true, or at least almost never true. But tell me, what was it that you argued in this article that you wrote?
Okay, so I did my research before I did this. So I looked at the UK, I looked at Australia, and it should be no surprise that other judicial bodies are undertaking, on various fronts, how to be more inclusive of different people with different faiths in the courtroom. And so they all have these kind of like bench books of guidance. And I wanted to see, well, we have one given this policy direction, but then there was one case that I read, and that's where I was like, oh no, that's not good. And that could now happen in BC. And it was a case from the UK where, and I believe the Feminist Current wrote about this case a while back. There was I think she was in her 60s, this lady who was an activist at a park in, oh my goodness, I can't remember the park in London, but she was essentially... Speaker's Corner, yeah. Is it Hyde Park?
Yeah,
something like Hyde Park, yeah. So essentially, to make a long story short, she was assaulted by an individual who her evidence was they presented as a male, and so under oath she kept referring to the accused as a male, and the judge interrupted her and said, excuse me, but the accused has asked that you refer to them using female pronouns, and she said, I'm used to thinking of this man who's a man as a man, and he essentially was not happy with that, the judge, and ordered her. Well, I mean, he ended up getting the accused got like $150 fine, which was obviously, anyways. That was quite shocking in and of itself. But then the judge refused financial compensation. Like, I don't know if it's like a victim surcharge or something to that effect. And part of that rationale from what I read online is that she showed bad grace on the stand. And I was like, wow, okay, this is that woman's evidence, and the identity of her assailant was at issue. And the second thing was that, I'm not a criminal lawyer, a criminal law lawyer, but the more severe an assault is, the more likely you're going to have a more severe punishment. So I think I can go on a limb here and make a generalization that if I'm assaulted by a grown biological male compared to a female, aside, I'm sure that there might be anomalies, but most likely I might be hurt more. It's just, again, that bad word that we can't say anymore. It's biology. So that really got me thinking. And then I looked at the similar guidance in the UK. And in the UK, they clearly state in their direction, if it is, try to accommodate those pronouns to the extent that you can. This is to the judges, up to the point where it's actually the substance of the judicial proceeding. Someone's gender identity is actually the subject matter of the proceeding, and you can't really avoid it. So you'll say something, and I'm on the other side saying something else. So, And I just thought, okay, this looks a little bit strange. So the first thing was witness rights. That's what really propelled me. I just imagined people on the stand being dictated how to give their evidence. And I'm not talking about gratuitous insults. I'm talking about them just giving evidence in good faith in their own words. And then I thought about it further, and I thought, okay, well, what if you and this is the other thing that I found out through my research, where a lot of profs at universities were asking students, first day in their first semester, everyone, stand up, give me your name, give me your pronouns. And there was one prof, I think he also taught gender studies, and there was a student that burst out crying to him in his office later, and basically saying, like, I don't know, and I can't answer the question. And then he wrote an article I read somewhere where he said, actually, I went about this the wrong way. You can't just ask people that question. Is actually something that many may be sensitive about. And I thought, well, you're kind of outing that person, and indirectly, you could possibly be outing their sexual orientation. And I just don't think that's necessary for a judicial proceeding. And I just felt like that's a bit of a reach. I mean, your privacy rights are limited in open court, that's for sure. But to the extent that this question, is it really necessary to get the proceeding underway? I just, not like this, automatic question to be asked at every proceeding. I just felt that was an overreach. And then finally, given what I learned this year about the gender dysphoria cases that your viewers might know about in BC, I realized, wait, some of these parents are coming to court where their child is seeking transition. They're trying to stop their minor child. And there we go. That's the contest. So one parent is saying, I would like to keep my child with their natal gender. And then their child, their adversary, unfortunately, is saying, no, I want to transition. And one of the orders that they're seeking is, you, mom or dad, are going to call me this pronoun, whether in court, whether outside, in our private life, always and forever. And that's an order that they are seeking under the Family Law Act, conduct orders. And I won't get into that. But I mean, if the court has come out with this type of policy, and you as a parent are seeking that, like, you're trying to make the case that, whether it's for your charter rights or otherwise, that no, I don't want to be forced to call my child by their preferred gendered pronoun. Like, you honestly think that the optics looks like you're going to have a fair shot when the court adopts an official policy like this? So that was the third point. So it was witness rights, privacy rights, and lastly, judicial impartiality, and also at a more institutional level, judicial independence, that they are not entering into the fray in this discussion. And so those were the arguments I made, and that's pretty much the gist of the article. But I mean, what I did say in the article that was eventually published, and I can tell your viewers what happened with the first two that were canceled, I also gave kind of a prologue in terms of what happened with the cancellation to drive home the point that this is really, it woke me up in terms of issues with expression within my own profession, and a profession that is known to argue some pretty controversial issues.
So there's a bunch of things that I'm concerned about with regards to this particular directive, but one of those things is what you mentioned around, like, there's been two major court cases that have been covered in the media in BC recently around this issue of a child being transitioned or wanting to transition, and one of the parents not wanting to put their child on this pathway towards, going on hormones. I mean, I think they already were on hormones, these kids at this point, but, they were wanting to get all these surgeries that, they're destroying their bodies for life, and they're teenagers or kids, they aren't in a position to make these kinds of decisions about something that's going to impact their entire lives and their health and their body forever. But if we're talking about in BC courts, saying that you have to use preferred pronouns, so if this is a male child, referring to them as she if they're wanting to transition to be a woman, or vice versa. I mean, that changes everything. I mean, this is such an obvious bias. Like, if then the court is essentially supporting the transition, and this parent doesn't have a chance.
Yeah, that's essentially the argument I was making as my third point, because I understand that the court is, if you read those gender dysphoria cases, always right at the start, the court will say, of course, they'll make it clear that that the minor was born their respective, or they'll use that phrase, sex assigned at birth. They'll make that clear, but then they'll say, out of respect for the minor, I'm going to use their preferred pronoun. And I guess if I was the lawyer for the parent, I would say, what about respect for my client? And then I would say, it's you, judge, that has to use the neutral minor. I also don't think that the judge should be referring to the minor with the pronoun that they don't want. But you're the judge, try to remain neutral, say minor, but that parent, and when that parent is giving evidence, and when their lawyer is advocating for their cause, you have absolutely no legal room to dictate how that lawyer is going to defend or pursue the case for the parent. And absolutely, you would not tell the minor and their lawyer how to pursue their case. So now we're left, and I have to back up here. So the reality is that after this came out, and I'm not going to give myself credit for the pushback, but what I heard is that it was not being followed. So a lot of judges are just not doing this. I'm sure there have been many discussions behind closed doors with the judiciary that we will never know about. But the reality is that some judges will ask, and what I've heard from my colleagues who have recently appeared in court, most are not even asking. So again, if you'd like to volunteer that information, you can do so. So if I was presenting my client who wanted to be referred to with their preferred pronoun, again, of course I would ask. I would ask the court, and I would even ask others. But I know that the limit is I can't be putting words into the witness's mouth. I know the limits of that because there are other rights in the room. Right. And I try to make the point in the paper that I'm not talking about provincial human rights law. So we all know that, in certain prescribed contexts, employment, tenancy agreements, offering services to the public, you can't just say, oh, you're trans, or, oh, you use a weird pronoun, you're not coming into my store. Maybe it's not common knowledge, but you can't be discriminating, whether it's gender identity or sex or religion. You just can't be using those grounds for discrimination. But the context in an open court where we're in an adversarial system, that's not what I don't believe that the Provincial Human Rights Code reaches into that. Now, there have been some people that said it does. I have not found a single case that says that. In Supreme Court, I'm not talking about the Human Rights Tribunal. I won't get into that, but in the Supreme Court, now we're left with uncertainty. I and my colleagues don't know what to say. If we get asked, what should we say? I'm sorry, my lord, my lady, if we can even say that anymore. I would prefer not to say, or I don't think it's required that I say that. Like, are we going to get in trouble with the Law Society if we don't? And I've already asked a practice advisor, what should I do? And I can tell you, probably all you need to know is the first line from the practice advisor to me was, well, obviously you identify as a female, as a woman. And I was like, okay, all right, well, there we go. I found that also insulting for me. It's like, I don't identify, I am a woman, but apparently I can't say that these days. So you can just imagine what they said. It's like, go back, read SOGIC's advice, and we think you should follow this direction. So there you go. But the reality is, again, judges are not following this for whatever reason. Some are, and I can also give you some other information in that I've also heard that now people are saying, what do we do about enforcement? So they're trying to think of ways to enforce this, the people who want this practice direction. I just find it funny because at the Court of Appeal, they never issued this, and they just kind of left it back in 2019. They just issued a direction saying, like, if it wasn't even about pronouns, but it did say, like, mix, if you want to be referred to in a certain way, just advise the court. But whether or not people have to follow that, whether, like, it's just advise the court, and I think they'll just do their best to accommodate. But I just have never seen this. I think in Manitoba they may have started something similar, but we don't know how that's going to hit the ground. So, yeah.
I mean, I see this as, like, similar to enforcing religious beliefs on people. This is ideological. I mean, in trans rights activists, they like to pretend as though this is a settled matter and there's no debate, but there is a huge debate. And most people around the world don't buy into the idea that you can just identify your way out of sex. I mean, most people in the world probably aren't even aware that this debate is happening. It seems like
so it's a very first world, yeah.
Yeah, but this is a Western debate, and a Western debate among, primarily, like, educated middle class people. So people living in North America, maybe people living in the UK. There's a debate in Australia, New Zealand, places like that. But in any case, I mean, insisting in the court, in particular, insisting that people adopt and accept this notion that you can have some kind of gendered soul, and that alters physical reality, that this alters your sex, that this alters material reality. I mean, I feel like that would be like forcing people to all go along with, Christian beliefs, or to believe that, to accept the notion that there is a God and God exists in the courtroom, which seems totally inappropriate. But I mean, is this even, like, legal?
Is it even legal? Well, I think the court, I'll recite to you what all lawyers should know intuitively, is that the court is the master of its own processes through its inherent jurisdiction. These directions are, there's one court direction from the Court of Appeal that says court directions do not have the force of law, but they are, of course, directions from the court, and unless you can show a good reason why you should not follow it, you should follow them. So the other court directions are really benign. It's like, when do I wear robes in court for trials? Or how do I correspond directly with a judge who, let's say, heard your matter, and you need to, like, you want to appear before that judge again because there's, like, some follow-up issue with respect to the proceeding. And so this one, it's within, forms of address. There are practice directions that say, when you're in Supreme, the proper form of address for a justice, a lady justice, is my lady, a male is my lord. And of course, there's been so much to try to get rid of that, and I don't know what will happen. I think at the Supreme Court of Canada, they just prefer justice. So again, that might be what ends up happening, but these are within the purview of the court, controlling its own processes. But again, I'm trying to make the argument that I think you might be stepping on some other established rights, right? I mean, you have the charter doesn't stop at the witness stand, and it's all, in terms of a hierarchy of rights, like gender identity as as a ground in provincial human rights legislation is God, and all rights fall subordinate to that. That's not the case. So all I'm trying to raise is I'm trying to basically, I can never say this directly to the courts, but you're going to run into problems sooner or later. There's going to be a mashup of laws, and I hope it's not as egregious as to what happened to Maria McLaughlin in the UK. But I've already seen some things that have caused me concern, but maybe in provincial court, in the human rights tribunal. But I don't know how things are going to proceed with this. It's funny because your audience might know Karen Litsky is a writer based in Vancouver who wrote. She's been following this, and so she wrote an article for Quillette, and in there she found another lawyer who, Jim Heller from Victoria, who wrote a letter to the judges, to the three judges. Provincial Court, Chief Judge, Chief Justice of the Supreme Court, and Chief Justice of the Court of Appeal, basically raising a flag like, I don't know what's going on here, but did you think of consulting anyone else? And basically the judges just wrote back and said something like, can't remember exactly the wording, but like, thank you for writing to us about practice direction, which advises how you can advise the court. I don't think that's it. I don't think it's just saying how you can. We already know that you can. It's that prompting, and now there's talk about, well, how to enforce that prompt. That I'm like, okay, I don't know, like that's pretty close to compelled speech to me in court. And going back to your earlier point about this is, if you don't think this is ideological, I would completely beg to differ, because the whole point of this is you're saying via self-declaration or self-identification that you are a specific gender. I may not subscribe to that. You may subscribe to that. This other person may be on the fence. It's not like this done deal that everybody, you're either, come on, get with the program. Like that's how it is right now. No, it's not. I don't know. That's what happens with social media, right? Like, if that's your point of view, that's all you're going to get from YouTube, and your reality becomes warped. That's why I stay away from social media, because I want, to the best of my ability, I try to get news from everywhere. And maybe these 200 some odd lawyers that signed that letter to try to remove the article are living under some reality that a lot of those lawyers other lawyers who contacted me, who will remain anonymous, and there were many, are not living in that universe. So can we at least talk about it?
Yeah, it's you're right. Social media has really impacted political and ideology debates in an enormous way, but certainly it's shaped perspective on this debate, because people, see what they see in their feeds, which is dictated by an algorithm. And so it's not representative at all of a majority or any kind of diversity. It's a very narrow, very small bubble, but it seems like everything. So yeah, people in these kind of progressive bubbles in places like Vancouver, for example, are really going to think, oh, everybody's on board with this. I guess this is the new normal. This is our new creepy term. The new normal is the different kind of new normal. But it's when I read media coverage about this directive, the media coverage was completely biased in only one direction. So, Lisa Nevins, I think, is one of the lawyers who really led the charge around this, who really pushed this directive. And it was weird. I read an article about the directive. I think it was in CTV or something like that, and they quoted Lisa extensively. And even she says, your job as a lawyer is to represent your clients, not to make statements about your own identity, which really seems to contradict her push to force the courts to use preferred pronouns. Because, it shouldn't be about you. Like, I mean, if you're a lawyer and you're insisting that the court use, they, them, their pronouns, I feel like that's kind of inappropriate, because that's not what it doesn't matter what your pronouns are. You're there to represent somebody else. I mean, you're announcing your ideologies or your religious beliefs to the courtroom, and I find it really strange.
Yeah, yeah, that I completely agree. I think that if maybe if I was asked the question, I would say, you may refer to me how you please. If you feel like referring to me using the male pronoun in open court, I would never say anything. I mean, there are many times that I have been misgendered. I don't know why some people get my last name, they think it's my first name, or just it's just such an exotic name, they don't know what gender. I don't care, because my identity does not rise or fall with how you misgender me, however you choose to refer to me in open court. I wouldn't dream of telling you how to refer to me. People mispronounce my name, people get it wrong, yeah, I've been referred to in correspondence with other lawyers as male. I just don't. I don't know. I mean, I can understand why people going through gender identity issues, it's sensitive for them, absolutely. But I mentioned in the article that you know what, going to court is not a fun experience. Some of the worst evidence can come out, and it's not a pleasant. I wouldn't even say it's a pleasant experience for judges all the time, but it's court. And other people have rights. And again, as a judge, you do your best to accommodate to the extent that you can. But this gets dangerously close to some other very, very sacred rights, in my opinion. That I kind of draw the line. I remember I didn't even know about this pronoun stuff, and I remember going somewhere with a friend, and he told me, "Oh yeah, I have a friend coming along, and their pronoun is they." And I was like, "I don't know what you're talking about, but okay." And I just tried my best to use that pronoun. I didn't even think about it. And like I'm not out here to gratuitously insult people, but as a lawyer, I had this ethical duty to raise a flag, and that's all I try to do. And unfortunately, fortunately, it's gotten a huge debate going, which, and I'm not going to give myself credit for it, but there have been a lot of other lawyers in BC that have reached out to me. So there's been an issue, and I can tell you from what I've heard, the judges know there are many that are not happy about this. And so what they end up doing with that information, it's up to them.
Right. And of course, like, thanks to media bias and how social media works, all of those other lawyers and voices are sort of invisibilized, right? Because, these are the prominent voices. These are the voices who are being quoted in the media, so on and so forth. And of course, because if anyone tries to challenge, they're censored. So, like, what happened to you? So you wrote this article, and I think you tried to publish it at The Advocate. Is that right?
Yeah. So the first go around, I sent it to the editor of The Advocate. It's a legal trade magazine in BC. All lawyers that if you're part of the Law Society, you're going to have a subscription. You're going to get it every 3 months, I believe. It's published. And the editor thought it was great, and he thought, okay, this is actually a really great opportunity to maybe do like a pro and con debate. And so he said, do you mind if I share your article with CBA SOGIC? I said, absolutely, no problem. I'd love to hear what they have to say, and they can do a rebuttal, and I can maybe do a reply. And unfortunately, they came back with threats of litigation, that if the editor published the piece, he might have a lawsuit under the Human Rights Code in terms of discriminatory publication because of the piece. And so that was one. And then obviously I went with Plan B. I guess I don't like it when people shut me up, so I went to Plan B. And then again, editor of Canadian Lawyer, which is this online, it's a really great magazine, actually, just kind of, different sectors of the law. You get different articles, and various lawyers across the country contribute. Again, he loved it. He thought, well, sorry, I shouldn't say he loved it. He thought, okay, it's a good piece. We'll publish it. And then it published on February the 6th, I think, was up for like 36 hours, maybe 72 hours. I can't remember. And then one lawyer thought it was a smart idea to do a lawyer rebellion and say, if you don't remove this, we're never going to contribute these 200 lawyers, that we're not going to contribute to your magazine anymore. And the thing that was probably the worst, again, lawyers have a right to say my piece is crap. I would never take that right away from them. But of course, the manner in which they didn't actually address the substance. It was just like, this is hate speech, this is bigotry, don't give her a platform. But do you want to at least address my concerns? Are they completely empty? Or do I have nothing to worry about? As if I have nothing to worry about, I'd like to know. That would give me peace of mind. But there were 3 benchers from the Law Society, and they, on Twitter, 2 of them were quite public, and the words bigotry, hate-fueled were used, discriminatory. And I was like, wow, okay, these are benchers. And yeah, nothing happened from that. Of course, the president of the Law Society, I think, got letters from other lawyers that this was completely inappropriate for benchers to be. I think one of them actually used his name, like he signed the letter as a bencher. And I think the Law Society president had to say, you can't do that. Like, if you're going to sign something like that, it has to be in your own personal name, not in your capacity as a bencher. But other than that, there was no slap on the wrist. There was no further discussion. I tried to, get the ear of the president to say, like, is this proper for a bencher to be acting like this to a junior lawyer and kind of ruin my reputation and denigrate me publicly? And basically, not much has happened.
Mm-hmm. I mean, and did Canadian Lawyer, did they give you a reason that they decided to take it down?
No, just another abject apology. It does not reflect. When does a legal opinion piece have to reflect the opinion of the editor? I mean, that's
Right.
the whole point. It's an opinion piece. So that was their pretty spineless excuse. And people picked up on that. And many lawyers told me that they wrote to the editor. Many lawyers told me that they wrote to the editor of The Advocate. I feel like after I did this, I feel like some older lawyers, they contact me and they said that if I said this, I might lose my job. And I was like, wow, that's really bad. Like, is that the kind of culture that we have in the BC bar? Like, is that, but somehow I feel like I opened something where like I was shocked, like on my LinkedIn account, there were some public, like there were actually some public support from lawyers and other non-lawyers. And I was like, oh gosh, are they sure they want to do that? But I feel like it's opening, like it's kind of like saying, hey, like maybe I can also say something. And anyways, to make a long story short, that there was this kind of like open thought exchange, that some questions, you were able to put some questions to judges, like not live, but that the CBA was able to kind of gather in some questions to put before the judges. And I mean, sure, I had my one question in there about the direction, but then there were so many other questions about, and questions that were maybe a bit overtly not happy with the direction. And I heard that the judges just declined to address those questions, probably because they already know that there are some issues. So, yeah, mate.
I mean, it's interesting to me how activism is driving these kinds of directives, these kinds of processes. Like, I mean, and I find it sort of odd that lawyers are speaking in these kinds of activist terms. Maybe it's not odd. I mean, maybe this has been common for lawyers for some time. I just sort of saw the role of lawyers as, not to be activists, essentially, to be more neutral. But, I mean, I saw there was a tweet, I think it was referenced in the Quillette piece by Karen. There was a tweet by this person named Naomi Moses, who's a lawyer, and she was one of the ones who pushed really hard to get your article taken down. And she tweets, "Thanks for the solidarity. I spent so much time and energy and heartache trying to prevent this hateful piece from being published. To the news that Canadian lawyer ran with it was so gutting." So I guess she pushed to get the Advocate not to publish, and then Canadian lawyer published it. So she pushed to get it taken down from that website or something. But I mean, anyway, like, I just found it strange. Like, thanks for the solidarity. Like, she's speaking like an activist. She's not, it's just so unprofessional to me, because I'm like, who are you going to represent as a lawyer when you're talking like this? Who is going to feel comfortable having you represent them? I guess she only wants to represent other activists or something.
Yeah, or clients that share that same ideology. I don't know. Yeah, it's funny. So many things came out from those tweets that I wasn't even aware that these individuals, like, there were so many people that just came out of the dark. I was like, oh wow, that they kind of outed themselves and said, yeah, I had a role to play in removing the Advocate piece, and again, a part of me wants to be like, good for you. You're standing up for what you believe in, and but you're also doing it in a way that publicly denigrates me, and you're not giving me the space. Like, again, I all of those tweets, everything, they have a right to. I won't call that hate speech. It's just very overly emotional and perhaps at times immature, the way that they're expressing their distaste for the article. But you're just not. You're not engaging with me, and you don't want to. And actually, I should mention, and Jen Gerson, she told me, there's a lawyer that she had found that wanted to actually write an engaging piece where he or she, whoever, was going to pick holes at my article in terms of the legality of things, or the correctness of it. And I was like, oh, fantastic. Like, after all I went through, I was like, this is so great. Like, I don't know who this person was. I never ended up seeing it. So that this individual never followed through. And no one followed through. So again, I remember contacting the CBA National Magazine, and the CBA, they have published article after article in support of this, and not one article in criticism. And I wrote to the editor of this magazine. I said, okay, well, you're supposed to be like a, cross Canada professional organization. Do you mind if I'd like to share some of my thoughts about some of my criticisms of this direction? And then the editor is getting into a debate with me, saying, well, are you sure it's compelled speech? Are you okay? Yeah, no, I am interested in, publishing your idea. Never went anywhere. He said, actually, I'm going to possibly hire a journalist, and they can do like a neutral piece. Never happened. So I just knew that organization is not interested in hearing the other side. Yeah, and I agree with you. It is. Yeah, I would definitely not speak like that. That does appear to be a bit unprofessional.
I mean, it's again, this is how this always goes. I mean, people don't tend to actually rebut these kinds of arguments fairly. They just shut it down as hate speech and bigotry. I mean, that happens to me all the time. It's very rare that someone will respond actually to what I argue with regard to gender identity. It's very common for instead people to refer to me as, transphobic or a bigot or hateful or dangerous or harmful or, even guilty of violence, which is all crazy. But it's funny how they really do show their hand. Like you said, a whole bunch of people came out on Twitter and admitted to bullying. This is bullying as far as I can tell. Like, they're bullying these magazines into censoring you, and trying to bully you. And I realized when I was reading this Quillette article that this committee, the Sexual Orientation and Gender Identity Committee, was founded by Barbara Findlay, who is the one who was responsible for taking Vancouver Rape Relief and Women's Shelter to court back in the 90s, because they refused to allow a male who identified as a trans woman to train as a counselor. They have a women only policy there for good reason. This is a shelter for women, very, very vulnerable women who've been through really serious abuse and are scared for their lives and are trying to escape violent men. And she said, like, she talks openly about her tactics, one of which obviously a primary tactic of hers is to file a human rights complaint. So she says filing a human rights complaint is an excellent pressure tool, because then it's not just about your opinion. It then becomes a legal issue, essentially. Is that true? How does that work?
Yeah, I mean, it obviously, whatever threat the editor of The Advocate received, that publication would be a discriminatory publication that is captured by the Human Rights Code. I mean, that's a great tactic. So not only do you try to say, okay, like, you cancel someone, but if you tell someone you're actually breaching human rights law, and at this point we're fitting whatever we can into publication. I mean, obviously the other prescribed contexts don't apply, but I'll be honest with you. My article that was eventually published by C2C, it went through so much vetting because there was so much fear that it might be discriminatory publication. Now, I'm very proud to say that C2C still went ahead with it and was fearless. But of course, they had to do their due diligence because that threat was looming always. And I mean, obviously, as I'm writing, I'm thinking, oh God, I hope this is not. I'm just trying to make a legal argument that, pursuant to the Groya decision from the Supreme Court of Canada, I, as a lawyer, have to pursue my client's interests, even if that means that I'm unpopular with the bench, with the bar. Like, you have to go very, very far to reach, inappropriate conduct in court when you're trying to zealously fight for your client's rights. And I'm just like, oh God, I hope this doesn't come across as this, and it doesn't come across as that. And I think Finley's tactic works. If whether it's legal or not, well, just go look at whether it sticks. Does it stick at the tribunal? The tribunal, in my opinion, I don't think that, with all due respect to the tribunal, they are very much on board with everything. And so they're one of those who are within the mind frame that gender ideology is not even an ideology. It just is. And if you don't accept it, you're probably discriminatory. So I mean, if that's where they start, and whether or not those decisions actually get judicially reviewed, first level Supreme, and then possibly appeal to the Court of Appeal, that doesn't happen often. So I guess we'll find out in the future how it goes.
Right. Why do you think it is? I mean, to me, this issue of gender identity is really, it's amazing to me how quickly activists have been able to really push through their ideology and push their ideology onto a variety of institutions, academia, journalism, the media, even like healthcare, like, I mean, women's groups, like NGOs, obviously LGBT charities and organizations, schools, elementary schools, high schools, politicians, and now the law. I can't even think of any other lobby group that's been so successful in pushing through their ideology and achieving their goals in such a short period of time without really much pushback. I mean, it seems to me like in BC, the legal industry really just caved instantly to these people, despite the fact that lots of lawyers themselves might disagree. Why do you think that is?
Oh man, I have asked myself that question so often. I've actually, yeah, I've mulled this over a lot. I mean, in a way, I almost have a, like, tell me if I'm wrong, but I feel like it was mostly this past. So, like I said, I didn't even know about Dr. Peterson until about a year ago. And I feel like, me coming from also a very lefty background, very all inclusive, I've always been just very much your kind of lefty. I mean, I was in gender studies, so I was always aware of these issues. I know about I understand the underlying argument about the oppressiveness of gender constructs and this and that, but something changed because at least when I was at SFU, you could at least talk about, there wasn't this like underlying subtext of like this like, I don't even know, this authoritarianism that you couldn't speak out of the box of this stricture. And the worst insult overnight became being transphobic. Like you would rather die than be labeled that. That's what I felt. And I think anybody, institutions, medical institution, even just like corporations, like they're just trying so desperately hard to not come across as anything that would show that they're not friendly to any and all demands of the LGBTQ plus two-spirited community. I mean, like I just don't know, when did that change though? Because before, at least we could have some semblance of a debate. Maybe, I mean, it was okay to talk about, okay, it's a woman's shelter. Is it proper to have, and then it was like, what you, like, and I've had friends that were like, okay, just cut me out of their life. Oh, I put a post on Facebook that said, hey, this looks a little bit concerning. Oh, transphobe, out she goes. And I just was like, whoa, I just don't know, like, how did this happen? I honestly don't know, Megan. I think is what I'm trying to tell you. I just don't know their success. Of course, I don't think it's a very open secret that I can't remember, but there is an organization. I feel like there's a law firm, Denton's, at the international level. They actually have a planned agenda of how to lobby properly for these changes in the law on various gender issues. I'm not even sure if it's that. There's got to be something that it's a concerted effort. I mean, you see it on TV, you see it everywhere. You know that the narrative is you cannot step outside of this line, and everybody knows what happens if you do. So I just don't know, what was it? What was it a gradual thing? Did it have something to do with COVID? Like I don't know. And perhaps I was the one naive enough or not infected with this mental frame that you can't speak, that then leaped me into controversy.
Yeah, I think about this question all the time, and I don't have an answer either. But I mean, I'm glad to hear that it hasn't impacted your career at all. I mean, these kinds of things always impact us in a variety of personal ways. Friends cut you out, so on and so forth. But I suppose we just have to kind of wait and see where this goes in BC anyway. Is that, we're just gonna, I mean,
Yeah, I don't know. I feel like maybe one day it will quietly be repealed and no one will even know it's been repealed. Or it's just going to get worse. Or it will just be the status quo, which I hope it'll just be. But, for now, myself and my colleagues, we still don't know what to say if we don't want to answer the question. And I still don't know what the repercussions of that would be. I hope that the judge would just respect that I prefer not to answer. And, again, at the same time, I don't want to get in a big fight with a judge if I don't have to, because you don't want to have a judge's wrath. But there are some actual issues that later on, I think, not even about introductions, but in terms of how the proceedings unfold. The next question for me is, okay, you've stated your preferred pronoun. Now the question is, do I have to use it throughout? Do I absolutely have to? And what happens if I don't? And then there's, costs orders, like is that considered improper conduct such that the court can use various powers that they have, including this thing called special costs. Like if you're the reprehensible conduct during the course of litigation, it would be mind-blowing if me declining to use someone's preferred pronoun in open court, whether it's because of my client or whether I just don't think that that's appropriate on my own conscience and beliefs as an individual, if that's going to warrant misconduct costs or contempt of court, we'll see. But that would definitely that would be litigated, and who knows? Maybe that's what we need. We need to have some pronouncement from a higher court that says, okay, I understand what you're trying to achieve with this, but here it goes too far. And I just don't know where that too far is. Where is that line? That's the big mystery right now.
Mm-hmm. Well, I mean, thank you for being brave enough to speak out about this and challenge it. I mean,
foolish enough.
Yeah. I mean, it's not easy, and I mean, somebody has to do it, right? There's somebody who's kind of got to go first. So
it had to be somebody young, and it had to be somebody at my vintage who can do these things. But I really hope that some older lawyers will step up and just at least give their 2 cents, and some of them have. And so I'm not, I can't be the poster child for this. I can't carry the torch. I mean, if other lawyers want to remain silent, well, then they shouldn't be surprised when these things come up, right?
Yeah, exactly. Yeah. It was great to talk to you finally.
Thank you, Megan.
Yeah, we've been in touch for a while, so it's been good to connect. So thanks for going through all this with us and helping.
And thank you for your work.
Thanks.
Thank you for your work. It's been I've gotten to know more of your work this past year, and you're definitely you're a lone soldier on a very empty landscape, it appears. But hopefully, that there are others that are trying to do their part. So
yeah, slowly and surely, a few people are coming out of the woodwork in Canada. So hopefully that those numbers keep growing. Thanks again so much for your time. I really appreciate it.
Thank you.
Okay, bye-bye.
Okay, take care. Bye.